and check my sequence.
I did that.
And then forget now, continue now.
Okay.
Because as somebody was saying that it's recording, and hopefully it is recording it on.
Okay.
So we will record the video.
Okay. Thank you. Okay. I think others will slowly join in. We have about 30 people who signed up, and about 4 or 5 here, and others on Zoom. So let me go ahead and start. Thank you again, everyone, for joining. My name is Vijay, and I actually represent, we started a nonprofit called 50IsNifty, which is for folks like our age who are 50, actually 45 plus. And a lot of things in our age, middle life, where we need to have information about different things. And so we conduct sessions on different like nutrition, exercise, finance, technology, etc. And then we have signed up with Royal Sword Library to do monthly sessions. Today's is basics on wills and estate, but next month we will have on retirement planning and things like that. So several more coming in. So today we have Phil with us. Phil, I will, without further ado, I'll let you start, and probably I think you can share your screen, Phil, and then we can start.
Excellent. All right. Let me just get in here. And can everybody see my screen? There we go. Okay, excellent. So let me just pull this up. And if I can have everybody on Zoom just hit the mute key so that way there's no background noise while I'm talking. I don't want any, I want to make sure that you guys can hear me okay and make sure that, we don't have any, problems with that. Let me just see here. And I'm going to minimize this real quick. And let me go and start this. There we go. All right. Can everybody see my screen okay? Those online or those on Zoom land, if you want to just give a thumbs up if you can see the screen okay. I think I see over VJ's head that the screen there in the library shows a full screen. So excellent. Good morning to everybody. My name is Philip Simon. I'm an attorney. I am a managing partner at Simon Hyde. I've been practicing estate planning for about 25 years now. I want to thank VJ and 50IsNifty for allowing me to come in and speak with you today and discuss basic estate planning documents that each of us should have, and basically what you need to know about those documents. You'll see there's my contact information there. This program is really, I like to call it a 300-foot view, as it were, of estate planning. It's not specific to any one situation. In fact, when I do leave time at the end for questions, I would advise people not to really get into their specific, planning needs or strategies that they have questions on, unless, you feel like sharing your bank account number with a room full of people you may not know. Typically, that's something where you'd want to schedule an appointment and come into the office, and we can talk about a specific strategy that might work for you. So if you have general questions about estate planning, more than happy to answer those. But any specific questions with regards to your situation, that's something that I'd recommend, calling my office and scheduling an appointment on. All right, let's begin here. Just some information about me. I'm admitted to practice in Pennsylvania and New Jersey. And there's my glamour shots photo. I graduated back in 1997 with my Bachelor of Science from the University of Utah, and I got my Juris Doctorate degree from Widener back in 2001. As I said, I'm managing partner Simon Hyde, and my practice areas include estate planning, elder law, Medicaid and veterans planning, trust administration, and probate. If you will, the entire gambit of wills and trusts, as it were. So let's begin. Most commonly, the area that I always get asked a question, when someone comes in my office is, what's my estate? What does my estate consist of? And just so you're aware, the definition, or we'll say the legal definition of an estate, is any interest that you own at the time of your death. that can be broken down into really two categories. You've got real property, land, buildings, attached buildings, things like that. And then you've got personal property, which is everything not real property. So that's cars, bank accounts, 401ks, the fork, knives, and spoons in the drawer, the Picasso on the wall. That's all under personal property. So, and I really appreciate BJ setting this up, and frankly, those of you that are on Zoom watching this, and those of you that are in person at the library are really ahead of the game, because most of the time when I am meeting with people to discuss estate planning or proper estate planning strategies, they're typically into their late 70s, early 80s. And depending on the type of strategy that we're trying to incorporate, sometimes the train has left the station. And so we're really limited in what we can do. The sooner you're able to create a proper, planning strategy, not just with your estate, but also with your finances. And, I'm happy that VJ has somebody coming in next week to discuss, retirement planning, things like that, because attorneys like myself that practice in estate planning work hand in hand with accountants, financial planners, tax professionals, people in that world, because they do have considerable overlap. Again, with the estate planning, the main reason why you want to plan ahead is protection and provide. So protect and provide for your spouse and your children. It avoids family conflicts. You're able to pass on your estate in a way that you want to do it. You get to provide for those relatives, family members, or even friends that might have special needs. And you leave a lasting legacy, which all of us hope to do. So what estate planning documents should people have? Well, the minimum estate documents that you should have are your last will and testament, and preferably something, and this is something that we'll talk about, preferably in your last will, a contingency for special needs trust. And I'll discuss that, like I said. A durable power of attorney, some people call them financial power of attorneys or general power of attorneys. An advanced healthcare directive. The old name was living will. People still use that name, but that's the new name is advanced healthcare directive, but it's also living will. And there's also a healthcare power of attorney that falls under that umbrella. And of course, a HIPAA authorization. So let's talk about your last will and testament. Obviously, a will is a written document signed in a manner prescribed by law, and it disposes of your property upon your death. I can tell you, for instance, in Pennsylvania, the manner prescribed by law is that a will has to be signed and witnessed and notarized. The witnesses have to be over the age of 18, and everybody has to be together at one time. Additionally, the Pennsylvania Supreme Court within the past 4 months came out with a case that invalidated a person's will that they actually did their notarization and signing online during COVID, because the law is very clear that everything has to be done in person. So, during COVID, obviously people weren't able to get out, weren't able to be in person to person. And the Supreme Court said, well, we don't get to write the law. We just get to say what the law says. And they said that the law is very clear that all signing has to be in person. So they invalidated that person's law. It created kind of a seismic shift, as it were, because a lot of us attorneys were doing a lot of stuff online with clients. And so, when that case came out about 4 months ago, literally every single attorney I know that executed a will over Zoom or online, that type of thing, literally was reaching out to their clients. And I mean, hundreds upon hundreds of emails a day were going out saying, we need to get you into the office and we need to re-execute this. So, but each state is different, just so you know. So Pennsylvania, you're required to be in person with a notary, with witnesses and signing there. There's two types of people to an estate, realistically. There's the testator or testatrix, if we're talking the female vernacular, and then you've got your executor. And of course, one of the ways to get around having to take everybody to the court when it's time to probate your will is you can do a self-proving affidavit. The way that a will and probate works is once somebody dies, your executor or loved one contacts your executor who's named in the will, and they take it over to the Register of Wills office in whatever county you're in. If you're in Chester County, they go to the Chester County Register of Wills office at the Justice Center. Same thing in Philadelphia or Montgomery County, type thing. The executor takes their ID with them, and as long as the will had a self-proving affidavit attached to it, they don't need to bring the witnesses. If the will does not have a self-proving affidavit, they actually need to bring both witnesses with them in order to open a probate. That's why it's important for, again, proper planning that when you're executing a will, you're also executing a self-proving affidavit. So your loved one's family, whoever name is your executor on the back end, is saving time and expense in trying to track down potentially people that may not be alive anymore. So it's important to always do that self-proving affidavit. Once they go to the Register of Wills, though, it takes about 10 minutes to open a probate. They'll fill out a probate petition. Most of the time they can do it there at the counter. They'll take an oath basically saying that they understand that as being executor, they're under a fiduciary obligation to act on the best interests of the estate, not the beneficiaries, but the estate. An executor basically has 3 jobs at that point. Job number 1 is figure out what all the assets are for the estate. Job number 2 is figure out what all the liabilities are for the estate. And job number 3 is use the assets to pay whatever liabilities or debts the estate has, and whatever is left gets distributed to the beneficiaries pursuant to what it says in the will. As you can tell, I kind of jumped ahead. So obviously you can see where I say nominates who's responsible to administer your estate. That's your executor. You can put in there guardians for minor children. You can have a provision in your will that has a guardian for minor children. Now, just because, and this is a little caveat that I give people, just because you put a provision in your will doesn't mean that it is going to be followed or being forced, especially it involves another section or area of the law. So for instance, a guardian for a minor child goes through what's called orphans court, which is separate from the Register of Wills office. So your will could be used as an exhibit and show what your wishes are, if you were to pass away, who you would like your children to go to, but it's incumbent upon that person to still go file for a guardianship to gain that over the children. A will basically can determine how and when your devisees receive their property that you leave to them. And you can determine how taxes, if any, are owed, will be paid and can employ tax saving strategies. That's the 300-foot view, as it were, of a will. Again, a will must be probated before it's effective. And this is what I tell my clients all the time is a will isn't in effect. It's not legally valid, quote unquote, until it's probated, which means you have to pass away first. So it's after your death. And, it's basically saying that the will is proof that it is your will. And that's why you have the witnesses sign it and the notary sign it, and notarize that the witnesses saw you sign, that everybody, that you signed the document, and, it's all legally valid. Court determination, basically saying that will is valid, is what, in essence, probate means. Sorry, just clicking that. The benefit of having a will and going through probate is you have court oversight, meaning that every step of the way, the court is watching what is going on. If your fiduciary or your executor who is acting as your fiduciary is not acting in your estate's best interest, they can be both civilly and criminally in trouble. On a civil side, they could be seen as fraud, which means that they would have to potentially pay back any money that was spent or should not have been spent for the estate. And they could be subject to what's called treble damages, which means 3 times the amount. So if somebody defrauded the estate to the tune of $100,000 under treble damages, they could be looking at fines of up to $300,000. So you want to make sure your executor knows that they have to do things the right way or they could be in trouble. On the criminal side of things, it's considered usually a felony 1 or felony 2 offense to defraud an estate. which carries a minimum of 10 years in jail and a minimum of a $250,000 fine. And just so you know, you could lose on both. So someone could be found responsible under civil law as well as be found guilty under criminal law. So don't think that, just because you got found responsible under one, that you're not responsible under the other. And the other thing about a will and probate is obviously it's a public process, meaning that anybody can walk into the Register of Wills office once your will, a probate is open, and see a copy of your will. They can see who your executor is. They can see who your beneficiaries are. They can see what you're leaving to people. And again, a will, even though it doesn't take effect until you pass away, it doesn't provide help for you while you're incapacitated or while you're alive. So you're hearing all the things like, okay, well, it being public, people can go in and see who my executor is, see where my property is going. If somebody isn't, as forthright as we all are, what's going to stop them from going and trying to steal that stuff? And that's exactly right. And that's why there's a thing called trust. And just to give you a little heads up, and this is a conversation that I typically have with my clients, is someone always asks, well, why would I use a trust over a will? Well, out of Ohio, about 5 months ago, there was a burglary ring. And basically what they were doing is they were going into the Register of Wills office and they were pulling the will that was probated. They were pulling the inventory that the executor had to file showing what all the assets are. And they were basically going to the deceased house, the beneficiaries' homes, and anybody else associated with the will. And they were burglarizing those homes because they had full addresses and names and everything like that on all those people. Now, thankfully, these people were caught, but that's one of the biggest reasons why you use a trust over a will, because as you can see, a trust is a private agreement. It doesn't get probated. A court doesn't have oversight on it. It doesn't have to be published. It's a private agreement between the settlor or the grantor. That's like, say, for instance, I'm the person. That's between me and who I set up as my trustee. Now, while I'm alive, I have what's called, excuse me, I have what's called a revocable living trust, meaning I am the grantor and I am the trustee. When I pass away, my trust becomes an irrevocable trust, meaning I cannot change the trust anymore because I am now dead. I have a second in-line trustee named who basically fulfills the obligations that I set forth under the trust, basically saying, here's what I put into the trust. Upon my passing, here's who it's supposed to go to. Under a will, that's what we call a bequest. And most of the time, a will, you're looking at taking at least a year before your beneficiaries can receive their bequest. With a trust, the average turnaround time to get the beneficiaries their bequest is about 3 to 6 months. Again, because you don't have to go through the court process. There's different types of trust that you can do. As again, I was just referencing a revocable living trust, but you can also set up irrevocable trusts. You can set up life insurance trusts, spousal trusts. I mean, every single word in the dictionary could have trust on the end of it if it really wanted to. The benefit of having trusts, obviously, you can have more than one beneficiary and how things are set up and how things are distributed to that person. You can even have sub-trusts under a trust, so they don't get a bequest outright the way that you would typically see in a will. A trust can be written or oral in Pennsylvania. Now, I put a little asterisk next to that because you never want an oral trust, because then you get into he said, she said. Trust should always be written. Any legal document should always be written, but especially a trust. And you can include what's called trust protector provisions, where if for some reason there was a problem with the document or the legislature changed the law that made part of the trust invalid, a trust protector can go in and act as a scrivener and correct any errors or change anything to make it compliant with the law. So again, these are all good things about a trust. Obviously, if there's something in a will that is incorrect or against the law, you can't go back in and change it because the person is dead. The only way that you can change a will is to execute a new will prior to the person dying. So, again, one of the benefits of using a trust. There's also what's called special needs trust. And I highlight this because it's very important, especially in this day and age. And a special needs trust can be set up through will-based planning or trust-based planning. And it's, in essence, it protects um, a person who has special needs or is disabled has been defined by the state as being in that protected class of people who are presently receiving government benefits. Because typically, when someone's going to receive a bequest, an inheritance under a will or a trust, as it were, that may kick them off their benefits. Well, by setting up a special needs trust or a supplemental needs trust, that trust in essence is a third party trust, which means it's for the benefit of that special needs person. It's not their items under their name, it's under the trust name, and the trust is supposed to be used to supplement or supplant the needs of that special needs person, so that way it doesn't get them kicked off benefits. An example I like to use, I did a trust last year for a client in Colorado whose son was severely injured in a car accident. They're going through rehab, and the eventuality is to get him to be able to drive again, but he's going to be in a wheelchair and everything like that. Well, the state is willing to give so much money, let's say $30,000, for a wheelchair accessible van. The family wanted a nicer van. They were looking at a van that was like $100,000. So, with setting up a supplemental needs trust and the family acting as trustees for that trust, can go out and take the state's $30,000 the state was going to give, then use the money that they put into the trust that, to pay the difference, the $70,000, as it were, to get him the van that the family actually wanted him to have. And again, it doesn't affect his benefits. So he's able to get the care the family would like him to get without having to be removed from, benefits. Um, the nice thing is, it's typically set up by parents for their children. So it expresses their desires on how they would like, the money or whatever is in the trust used for that special person's benefit. It protects assets from creditors or predators of the disabled person because it's a third party trust. The creditors can't go after that trust because it's third party. It's not considered the special needs person's property, so they can't try and attach it and go after it. It's the property of the trust, who is the parents. And you can extend the life of the asset. So even if the special needs person were to pass away, you could then say whatever is left in the trust can go to other family members and decide how that is done. So that's will and trust-based planning in a nutshell, as it were. The other two documents, like I was saying, the next one is a durable power of attorney, or DPA, otherwise known as a financial power of attorney. This is basically where you are giving an agent the power to act on your behalf in financial matters when you are unable to act. Not unwilling, but unable to act. And it doesn't have to be that you are a vegetable in a hospital, for instance. That's the one that most people know, but it doesn't have to be that situation. It can be that you are going out of town, you're going overseas, and you need someone to handle your banking while you're away. A typical financial or durable power of attorney can be springing or immediate. Springing basically is saying that until a condition happens, so until you become incapacitated, it's not in effect. An immediate power of attorney is the minute you sign it, it becomes in effect, and that person can act on your behalf. And again, durable just means it stays in effect while the principal, the person that's giving the power, becomes incapacitated. And I have on there, mentally incapacitation, but it could also be physical incapacitation. Again, the one that most people use is the person is a vegetable, type situation. Advanced Healthcare Directive, HCD, also known as, I said, a living will, or a healthcare power of attorney. And this basically, just like a financial power of attorney, allows someone to make medical decisions on your behalf. Now, there's two sides to it. The healthcare power of attorney side of things is while you are still alive. And let's say you're just going in for a general surgery and the doctor needs to share information or get information with a family member. You can name that person as a healthcare power of attorney to be able to discuss those matters with your doctor. Then you have end of life decisions, also known as living will or the advanced healthcare directive. And that's basically where you're getting into the specifics of what you as the grantor wants to have happen to you in various situations. And again, we're talking last stop at the train station situations. Your condition is irreversible. You are completely unable to communicate. You have no ability to eat, drink, care for yourself, breathe, anything like that without the aid of a machine. Okay. And the ultimate question becomes is, would you like to be in that condition? And would you like life-sustaining measures performed on you in such a condition? And the person gets to make their own choices. I've had people say, yes, I want to be on an incubator. I want to receive nutrition or hydration. I've had other people say they don't. As I always tell my clients when they're executing an advanced healthcare directive, there is no wrong answer. There's just your answer. So whatever works for you is what the doctors are going to follow. And the doctors have to follow that because this is a legally binding agreement. Okay. And similar to a financial power of attorney, a healthcare power of attorney and advanced healthcare directive can either be springing or immediate. So again, springing being that you're in an incapacitated state, or it could be immediate. That means, the minute you sign it, it's active and working right there. The last form is HIPAA. Now, everybody knows about HIPAA forms. Every time you go to any type of doctor, medical facility, dentist, whatever, you're typically signing a HIPAA form. But a lot of people don't know what a HIPAA form actually does. And what a HIPAA form does is it authorizes that medical facility, doctor, dentist, nurse, whatever, to share your medical information with third parties. They're the keeper of the medical information, and a lot of time, and legally, they're not allowed to share it unless you give the okay. And when you give the okay, you can also say who it applies to. As you can see, covered entities, which is considered HIPAA, involves healthcare providers and releasing your information to authorized recipients. HIPAA, of course, has a criminal fallback, as it were, for unauthorized release of your private information. So if you didn't sign a HIPAA form and your doctor's office distributes that to a third party, they can be criminally liable. And most of the time, when you go to the doctor's office, each doctor's office has their own HIPAA form. You can go on Google and just type in HIPAA form. It tends to be a very basic, generic form. It isn't state specific per se. It's more practice specific or office specific. But realistically, it's just letting you know that you have the right under HIPAA. You as the grantor of the right, uh, you know, are understanding that you are the one that controls that right on who gets to see your medical information. So how will healthcare providers know that you have an advanced healthcare directive, a living will, or HIPAA authorization? There's different ways. So once you execute these documents, how do they get into the hands of the people that need them? There's online services that are available that that can make them available to most hospitals or doctors or things like that. Two of the big ones in the industry are DocuBank and Legal Directives LLC, where they actually keep a copy on their cloud, and then doctors, medical facilities, dentists, anything like that can actually pull it off the cloud. They provide you like a card that lets whatever doctor, anything like that, know how to authorize it, and they have a code and everything. You can always carry the documents with you. I always advise my clients, especially in a healthcare directive situation, is any doctor you go to, they get a copy. Any hospital that you frequent or is close to your house, they get a copy. Dentist gets a copy. Your agent gets a copy. If you're keeping the documents in your home, anytime your neighbors or whatever like that come over to visit, you show them where the copies are. You keep a copy in your glove box in case, because obviously when if you're in a car accident and the paramedics are looking for information, that's one of the first places they look is in your glove box. I have other people that create healthcare power of attorney little cards that go in their wallet or purse, and again, that's something you can do as well. With regards to healthcare powers of attorney, HIPAA forms, financial power of attorneys, durable powers of attorney, you don't need an original. In fact, I put provisions in my documents that say that a copy is just as good as an original, because again, the purpose of having these documents is to be able to get them in the right person's hands, to share them and make sure that they are easily accessible, because a lot of times you're going to be talking time is of the essence when you need to use these documents. So again, a comprehensive list of estate planning is, of course, your last will and testament with a, you don't have to use it, but with a contingent supplemental needs trust provision, a durable power of attorney, a healthcare directive, living will, medical power of attorney, a HIPAA authorization, and then the ability to store documents, whether it be online and doing it that way, or doing it, where you're just keeping it copies everywhere. Now, I will put a little caveat to that. Although you can have copies of your healthcare power of attorney and financial power of attorney, you cannot make copies of your will. Pennsylvania, depending on the state you're in, Pennsylvania law specifically says that only an original will can be probated. Using a copy creates a dichotomy under the law, and the courts don't like that because it creates too many headaches on the back end, and that's not something you want to do to your loved ones. And then, of course, another comprehensive planning strategy could be the standalone trust that we discussed, setting it up like a supplemental needs trust, a revocable trust, irrevocable trust, etc. But as a minimum, this is what I always tell my clients. You want to at least have a will. You want to have your financial power of attorney, your durable power of attorney. You want to have your advanced healthcare directive, and you want to have a HIPAA authorization. In the grand scheme of things, I know I put numbers 1 through 4 there. They're all equally as important as the other. If you want to highlight 2 that are must-haves in this day and age, I would say your last will and your advanced healthcare directive. Durable financial power of attorney isn't as important anymore now that we have online banking and the ability to pay bills online and do all that. It was a lot more important back in, the 70s and 80s when people still had to go into the banks and, do their banking in front of a teller and everything like that. The one thing I will tell you is even though you might execute a durable power of attorney, financial power of attorney, you anytime you're dealing with banking, financial institutions, Fidelity, Vanguard, anything like that, or even the bank down your street, PNC, Wells Fargo, you want to go in there and you want to make sure they don't have their own specific form. And if they do, fill it out as well. Just so everybody in the room is aware, Wells Fargo is famous for not accepting durable or financial powers of attorney. They want their form filled out and signed. And a lot of times when you're going to use this document, well, the person that granted you the power can't get in there to sign anymore. So again, it comes with a little, pre-planning strategy is when you're doing these types of documents, when you're doing this type of planning, make sure that any agency that you need to deal with or any entity that you need to deal with doesn't have their own form as well. If they do, great, get a copy of it, fill it out, and then they have it on file. I can tell you, Christiana Care down in Delaware has their own HIPAA form. But once you execute it, they upload it to their system. And then anybody that uses Christiana Care for any service, that HIPAA form is online. You don't have to sign it each time. Same thing with regards to the advanced healthcare directive. If you have one and you go into like a Christiana Care, they will automatically upload it and have it in their system as well. So, if you're seeing a doctor in Claymont or you're seeing a cardiologist in, Smyrna, Delaware, they'll be able to access it either way. Thank you guys for listening. I know I just said a lot and threw a lot at you. So, does anybody have any questions? And I'm going to get some coffee while you figure it out.
Yeah, I'm going to unmute. Can you hear me?
Yep. Can hear you just fine.
Okay. And others also any questions, please? Okay.
So, awesome information. Thank you. Really appreciate it. The question that I have is, in the list of the top priorities, I would have thought that you would have had trust, revocable or permanent trust also in there, but I did not see that. So that's one question. Second is, what are the tax implications of trust versus a will, for especially considering probate?
Okay, so let me answer the first question if I heard it correctly. I'm sorry. getting a little bit of an echo, so I just wanted to make sure. So the first question was, why wasn't trust the first planning strategy? Oh, I'm sorry. Can you hold on just 1 second? I'm just gonna do this real quick. Yeah, what's up? Maybe later. I'm busy. Okay, bye. Whoops, you did hear that. Never mind. I'm down at, just so everybody knows, the reason why I mentioned Delaware before, I'm actually down in Delaware. My son is a national karate champion, and they're doing a clinic down here that he's one of the ones teaching at it, even though he's only 8 years old. So um, that's why I'm sitting in the car while he's doing that. But if I heard your question correctly, and VJ, you can correct me if I'm wrong because you're a little closer to the microphone. I wasn't sure if there's a microphone in the room that's that you guys can use so I can hear questions a little better. Why wasn't trust-based strategy the first one offered over will? Because not everybody's the same. Every person is different and every strategy is different. So I include a provision about trust-based planning, but again, if a trust doesn't want to work for somebody, it doesn't have to work for somebody. Everybody's different. I had a client last week that I would have thought was perfect for a trust-based plan, and they wanted to use just a will, because one of the main reasons against using a trust-based plan is you have to remember to move things into the trust. If you don't put things into the trust, it's not going to do you any good after you pass away. And you're still going to need a will at that point, because then your executor is going to have to move everything over into your trust, and you're just creating more work on the back end, and so that's again, one of the reasons why some people use wills, some people use trust, but there's no right way, wrong way. There's just the way that works for you. And I'm sorry, VJ, could you tell me what the second question was again?
What are the tax implications of a will versus trust? Especially the probate process and will, and then the trust.
The tax implications, interest.
Sure. So realistically, what you're basically talking about is, and I'm gonna highlight Pennsylvania. So Pennsylvania has inheritance tax. They don't have a state tax. The federal government has an estate tax. And how do you get around paying estate tax or, inheritance tax? Well, presently, under federal law, if your estate is valued at less than $16.8 million for an individual or $26 million for a married couple, you don't pay federal estate taxes. For Pennsylvania, again, they don't have inheritance tax. They don't have estate tax. They have inheritance tax. And depending on what you're passing to your children, it's valued at different amounts. So for instance, anything you will or bequest to your children or even pass through a trust still has to pay inheritance tax. Children is at 4.5%. Any family that isn't a child is taxed at 12%. And anybody that isn't a family or relative is taxed to 15%. Now, there are exceptions to that tax. Minor children are not taxed. Special needs children are not taxed. Charities are not taxed. Everybody else pays. The story is the government's going to get you coming and going. So, there's really no way around that tax. And most of the time, your estate is the one that's paying that tax. So before a bequest is given to a beneficiary, either under a will or under a trust, your executor or trustee has to file with the state the inheritance tax return and the estate tax return. Again, as long as your estate is underneath the federal exception, you don't owe federal estate taxes. If it's over, then you do owe federal estate taxes, and that starts at 1%, and it goes all the way up to 37%. Same thing with regards to inheritance tax. When you pass away, and either through your will or through your trust, your executor or trustee has to file an inheritance tax return, where they're basically going to take all the assets and they're going to add those all up. They're going to take the liabilities and they're going to minus those, and they're going to say, here's what the net, estate value is. And then depending on who is getting that, not how they're getting it, but who is getting it is taxed at that rate, which the estate is responsible for. Now, the estate can use the money from the estate to pay that, so the beneficiary ultimately gets less, but that's how it's done.
Thank you.
I have a question. I think once the will or the trust is created,
Mhm.
is it necessary every year to make a change, or at least every year you should relook at it with the attorney?
And that's a fantastic question, and it's something that more attorneys actually should do. What I do is, anytime I have a client and we execute their estate documents, it automatically becomes an entry on my calendar that I follow them up every year on that date. And I send them a very simple 2-email question. How you doing? Has there been any changes that require, redrafting any of your documents? I probably send about 50 plus of those emails a day. The vast majority of the time, I get, responses back saying, "Hey, Phil, thanks for reaching out. Nope, everything's good. Talk to you next year." Every once in a while, though, I do get a client saying, "Oh my God, thank you for reaching out, Phil. Someone that we had as a backup executor on our will passed away. We need to update it to remove that person and put somebody else in there." The other thing is, I've got a couple clients, and instead of waiting, um, for my email each and every year to remind them that they need to be looking at their estate documents, they pick a random day throughout the year that they look at their estate documents. For instance, I have a very good client, and he's been a client now for 20 years. He chose Arbor Day. Why Arbor Day? Why not Arbor Day? It's a day that he knows that every year on Arbor Day, he looks at his estate documents and sees if there's any changes, because he doesn't want to wait a full year for me to send him an email. So that works for him, and that's great. And every Arbor Day, I get a very lovely email from him saying, "Hey, Phil, it's Arbor Day. Happy Arbor Day. Everything's good with my estate plan," type situation. But again, that's what works for him. So a lot of attorneys don't have that follow-up, though. So it is highly advisable that at least once a year, you're reviewing it. Kind of like, your taxes. Every year, the federal government gives you your federal credit report for free through all the big ones, TransUnion, Equifax. I always forget the third one. But you're allowed to pull your report every year for free. So the same reason, every year you should be looking at your estate documents, because when it comes time to use those documents, it means that you're unable to change them at that point. You can't dig yourself back up from the ground and re-execute a will after you die type situation. So that's why it's important to always keep those documents up to date.
Good, thank you.
I have a question. Is there a need to create more than one trust? Let's say you have a business or an LLC. So do you put that all in one, or is it multiple trusts, so that if something does happen legally, you have protection versus personal versus business property?
Sure. So here's the thing I always tell people with regards to protecting your assets and using a trust. A revocable living trust, an RLT, is in essence the mirror image of you. Okay. And so as such, since you have full access to control those assets, whatever you put into the trust, those assets, regardless of the fact that they are in a trust, are still able to be gone after from a creditor's perspective or someone wanting to sue you. The only time a creditor or someone wanting to sue you can't go after your assets is if you don't own the asset anymore. And that's what's called an irrevocable trust. An irrevocable trust, when you set it up, you're the grantor, and you're granting your trustee, whoever you name, and it can't be you, the power to take that property and remove it from your name. Since it's not under your name anymore, you have no access to it. You have no ownership for it. You have no responsibility for it. You're not taxed for it, everything like that. The problem with that is you just gave an asset to somebody else that you better trust, your trustee. And again, your trustee can't be you. It can't be your spouse. It has to be a third party. Again, the ultimate goal being that upon your passing, that your trustee will distribute what is in the trust to the beneficiaries. But as far as planning strategies go for protection, the only way to protect those assets from creditors or lawsuit is by using an irrevocable trust. You can't protect it when it's in a revocable trust.
Thank you.
Mhm.
Any questions on the Zoom, Yugandhar or Fayed?
I'm good, Vijay. Thank you. These are all very good points. Thank you so much.
Sure. I actually have a couple questions, Phil, from someone who couldn't join. I think one question is, what is the best way to leave property to the kids?
That I would say that's a conversation that you want to have off Zoom and actually sit down with your lawyer, because that's specific planning strategies, and there's no one way, there's no cookie cutter that fits everybody's situation. So, what's the best way to leave stuff to your kids is determined by talking to an attorney and figuring out what the best way to leave stuff to your kids, because some people want their kids to have stuff outright. Some people want their kids to have it at different intervals or ages. Doing it outright, you can just give it to them outright at different intervals or stages. That's, talking about setting up like a minor's trust or a children's trust that doesn't, end when the kid turns 18 or 21. It continue, till the kid's 50 years old if you wanted it to. So, that really is situational dependent that you would want to talk with an attorney about.
Okay, sure. And I think another question was, amongst Roth, IRA, and 401k, is there an order in which withdrawals should be made? Are there tax implications for leaving money in these accounts?
So that is a fantastic question, but it's a question for a lot better for next week's Zoom with your financial planner that's talking about retirement funds and things like that. That deals more with tax scenarios than it does with estate planning. So I would advise saving that question and asking it next week to that gentleman, because even though our words interact, I deal with the end. That's more of the beginning, planning, because that's taxes while you're still alive and everything like that. So.
Okay. Any more questions? Okay. I think, again, thanks everyone for joining, and thanks, Phil, for your time. I do have, let me actually share my screen. So I do have Phil's information on our website under experts. So if any other questions anytime, actually, let me click on that real quick. So there are other folks also here, but then Phil's information is here. And as I said, the next month's talk is on retirement planning for midlife folks, and we'll continue to do more. And if you guys get on our website, maybe register and let us know anything else you want to get information on. We'll try to do that. Any other questions on the Zoom? Everyone good? Okay. Thanks, everyone. I will close. Thanks, Phil, again. Have a good... Oh, was there a question?
No, I'm good, Vijay. Thank you.
Oh, okay, great. Okay, thanks, everyone. Let me close the Zoom. Share.
Thank you, everybody.
Thank you,
Thank
Phil.
you all. Have a good weekend. Thank you. Bye-bye.
Have a good weekend, everyone.